Stop what you are doing, because what just happened at the Supreme Court does not just change gun laws, it obliterates the entire legal framework that dozens of states have spent the last 2 decades building. And here is what makes this moment unlike anything we have ever seen before in American constitutional history. A 9-0 decision. Not 5-4, not 6-3. 9 justices, 0 dissents, including Sonia Sotomayor, including Elena Kagan, including Ketanji Brown Jackson, the 3 most reliably anti-gun justices in Supreme Court history, all voted the exact same way as Clarence Thomas and Samuel Alito. Let that sink in for a second. These are justices who have spent their entire careers defending gun control, justices who dissented in Heller, justices who dissented in Bruen, justices who have consistently, repeatedly, and forcefully argued that governments have the authority to restrict firearms in the name of public safety. And when they looked at what states have been doing, the permit cards, the waiting periods, the mandatory training gauntlets, the subjective denials, minds, and said, no, this has gone too far, you are not watching a political shift, you are witnessing a constitutional earthquake, not a tremor, an earthquake. This was not a close call. There was no agonizing over competing rights, no split opinions, no partial concurrences watering things down. This was a unified, unambiguous statement from the highest court in the land that the Second Amendment means exactly what it says, and that decades of state-level gun control infrastructure has been violating it. The fact that Justice Sotomayor, Justice Kagan, and Justice Jackson all marched in lockstep with the conservative majority sends a definitive message to every state capital in America. The federal and state governments had pushed their gun control agendas so far past the constitutional line that even their most reliable defenders on the bench could no longer look the other way. By the time you finish this, you are going to know exactly what the court struck down, how it hits every single state differently, what you can legally do right now that you could not do last week, and, critically, what is coming next and how to protect these rights before states try to claw them back. If you have ever owned a firearm, considered owning one, or simply cared about constitutional rights in America, this is the most important thing you will read or watch this year. Let us get into it. The Supreme Court handed down its decision in a consolidated case that bundled together Second Amendment challenges from multiple states and federal statutes into one definitive, historic ruling. The question before the court was deceptively simple. What level of constitutional scrutiny applies when the government tries to restrict your right to keep and bear arms? For years, lower courts had been applying a weakened standard, what is called intermediate scrutiny, which gave legislatures wide latitude to experiment with gun restrictions as long as they had a plausible public safety reason. Courts were deferring to politicians, and politicians, sensing that latitude, kept pushing further and further. Permit cards, 10-day waits, 16-hour training mandates, good cause requirements, discretionary denials, each new restriction built on the last, until the system in states like California, Illinois, and New Jersey had become less a regulatory framework and more a bureaucratic obstacle course designed to exhaust citizens out of exercising a constitutional right. What the Supreme Court said is this: no more. Chief Justice John Roberts wrote a majority opinion for the ages, and the language is historic. The court held that strict scrutiny, the highest level of constitutional review, the same standard used to protect your free speech, your religious liberty, and your equal protection rights, now applies to every single Second Amendment restriction in America. The opinion states clearly that the Second Amendment codifies a pre-existing natural right. It is not a privilege granted by government. It cannot be conditioned on government permission, bureaucratic approval, or artificial delay. The default position is liberty. Any restriction on that liberty must survive the most exacting constitutional scrutiny. This is not a minor procedural shift. This is a complete inversion of how gun law has been litigated for decades. Under strict scrutiny, the burden falls entirely on the government. They must prove that a restriction is narrowly tailored to serve a compelling interest using the least restrictive means possible. Almost nothing survives that standard. That is the point. The court also did something crucial that goes beyond simply changing the legal standard. It explicitly and permanently rejected what is known as interest balancing. For decades, anti-gun politicians relied on a simple trick in lower courts. They would argue that even if a law infringed on your rights, the government's interest in public safety was more important than your individual liberty. Judges would nod along, weigh the interests, and uphold the gun control. The Supreme Court has killed that approach once and for all. Rights, the opinion makes clear, are not subject to interest balancing. You do not weigh whether free speech is worth the cost. You do not weigh whether a fair trial is efficient. And you do not weigh whether the Second Amendment is socially convenient. Constitutional rights are not policy preferences to be balanced against government interests. They are rights, full stop. And then the court went further still. Rather than leaving it to lower courts to apply strict scrutiny case by case, which would have taken years of grinding litigation, the court identified 5 specific categories of gun regulation that fail constitutional scrutiny on their face and are now unenforceable nationwide. 5 categories. Every state in America needs to understand what they are. The first category is permit-to-purchase systems. These are laws that force you to get government permission before you can buy a firearm, not a background check, a permission slip. Illinois called it a FOID card, the Firearm Owner's Identification Card. New Jersey called it a Firearms Purchaser Identification Card. Maryland, Massachusetts, Connecticut, Hawaii, Rhode Island, they all had versions of this. You had to apply, wait weeks or months, pay fees, submit fingerprints, and hope some bureaucrat decided you were worthy of exercising a constitutional right. The court was emphatic. Prior restraints on constitutional rights are unconstitutional, period. You do not need a government permit to attend a church. You do not need a government permit to write a newspaper article. And you do not need a government permit to buy a firearm. These systems are dead. The second category is extended waiting periods. Most Americans have heard of waiting periods. California had a 10-day mandatory wait. Florida had 3 days. Rhode Island had 7. Illinois had 72 hours. The idea, sold to the public as a cooling-off period, turned a straightforward commercial transaction into a bureaucratic ordeal. Here's what the court said. States can require a background check. That is entirely legitimate. But the moment that background check clears, the firearm must be released. If a background check takes 12 minutes, holding that gun for 10 days is unconstitutional. Any delay beyond what is functionally necessary to complete the check is an unconstitutional burden on a fundamental right. California's 10-day wait is gone. Florida's 3-day hold is gone. Rhode Island's 7-day cooling period is gone. Illinois' 72-hour wait is gone. The third category is mandatory training prerequisites. Several states required applicants to complete hours of government-approved firearms training before they could obtain a carry permit. Sounds reasonable on the surface, but the court drew a sharp and definitive distinction. Training can be offered. Training can be encouraged. Training is something every responsible gun owner should pursue, but the government cannot make you complete an 8-hour, 16-hour, or multi-day training course as a prerequisite to exercising a constitutional right. That is the equivalent of requiring a civics test before letting someone vote. It becomes a gatekeeping mechanism, one that prices working-class citizens out of their rights through cost and time, not a safety measure. Mandatory training prerequisites are unconstitutional. The fourth category is good cause and proper purpose requirements. The remaining may-issue jurisdictions, California, Hawaii, Maryland, and certain counties across New York, required carry permit applicants to prove they had a special demonstrated need for self-defense. If you could not show you were being stalked, or that you transported large amounts of cash, or that your profession documented specific dangers, a bureaucrat could simply deny your application. The court said the right to self-defense is inherent. It does not need to be earned. It does not need to be auditioned for. Every law-abiding American has a sufficient reason to want to carry a firearm for self-protection, and the government cannot require you to prove otherwise. Good cause requirements are gone. The fifth category is discretionary approval systems. This is the catch-all that underpins all the others. Any system where a government official has subjective discretion to deny a permit based on suitability, character, reputation, or any other nebulous standard is now unconstitutional. If you meet objective criteria, you are of legal age, you pass the background check, you are not a prohibited person, the permit must be issued. No exceptions. No wiggle room for local officials with personal agendas. No more local police chiefs denying you a permit because they do not like your reason or your face. America is now uniformly shall issue, coast to coast. Now let us talk about your state specifically, because this ruling does not land the same way everywhere. The most affected states are California, New York, New Jersey, Illinois, Massachusetts, Maryland, Hawaii, Connecticut, Delaware, and Rhode Island. These states had layered nearly every one of the 5 struck-down categories on top of each other into dense, interlocking systems of restriction. Their entire regulatory infrastructure is collapsing simultaneously. In California specifically, the 10-day waiting period is reduced to background check processing time, which averages between 2 and 4 hours for most applicants. The firearm safety certificate is no longer a purchase prerequisite. It becomes entirely voluntary. Every remaining may-issue county must convert to shall issue immediately. The web of restrictions that California built over 30 years is being dismantled by a single unanimous opinion. In Illinois, the FOID card system, one of the most restrictive purchase permit frameworks in the country, which forced citizens to apply and wait for a state-issued card just to be eligible to purchase or possess a firearm, is struck down in its entirety. The 72-hour wait is eliminated. You walk in, pass the check, walk out. In New York, the training mandates embedded in the Concealed Carry Improvement Act are void. The good moral character standard for permits is void. The sensitive locations framework, which essentially banned carry everywhere in the state, faces near certain strict scrutiny failure in follow-up litigation that is already being prepared. In New Jersey, the firearms purchaser ID card requirement for handguns is gone. One of the oldest permit-to-purchase systems in America, in place since 1966, is now unconstitutional. The moderately affected states, Washington, Oregon, Colorado, Minnesota, Michigan, Pennsylvania, North Carolina, and Florida, lose 3 to 5 restrictions each. Florida loses its 3-day waiting period. Washington and Oregon lose training mandates tied to their carry systems. Colorado faces immediate challenges to its recent wave of local-level discretionary restrictions. The minimally affected states are the 25-plus constitutional carry states, Texas, Georgia, Tennessee, Arizona, Montana, Oklahoma, Ohio, and others, that already operated shall-issue or permitless carry systems with no purchase permits. For gun owners in these states, daily life continues as normal, but the litigation victory here still matters enormously. It locks in a constitutional floor under their existing laws that can never be undercut by future legislatures. Here is what changed for you on the ground, effective immediately, depending on where you live. You can now buy a handgun without a permit card. If you live in Illinois, Massachusetts, Connecticut, Maryland, New Jersey, Hawaii, or Rhode Island, you no longer need to pre-apply for a purchase permit. Walk into a licensed dealer, present your ID, fill out the federal form 4473, pass the NICS background check, and you are done. Same process as buying a rifle in most states. Same as it should have always been. You can now carry concealed without proving special need. If you live in a former May issue state, the good cause standard is gone. You apply for a carry permit, you pass the background check, you meet the objective requirements, and you get the permit. No interview, no character review, no audition before a hostile bureaucrat. You can now take your firearm home the same day your background check clears. No more 10-day California hold, no more 72-hour Illinois wait, no more 7-day Rhode Island cooling period. The moment the NICS check comes back approved, the dealer must release the firearm. Waiting periods that extend beyond that point are unconstitutional. You can now pursue a carry permit without completing mandatory training first. If your state required 8, 12, or 16 hours of classroom and range instruction before issuing a permit, that prerequisite is gone. You can still take training, and you absolutely should because responsible gun ownership matters, but no government can make it a legal condition for exercising a constitutional right. You can now apply for your permits with confidence that objective criteria, not subjective judgment, will decide the outcome. No more denial based on community standing, no more rejection because a local official does not like your attitude. If you meet the legal requirements, the permit is yours. Period. Now let us look at how states are responding, because the picture is not uniformly compliant, and what happens in the next 12 to 24 months will determine whether this victory holds. The first category of response is immediate compliance. The constitutional carry states and most shall-issue states already function within what the court is now requiring nationally. Texas, Georgia, Tennessee, Arizona. Their systems were already built on the default to liberty standard. Their attorneys general have issued statements confirming full compliance. For gun owners in these states, it is a victory lap. The second category is delayed compliance. California, Washington, Oregon, Colorado, and Michigan are indicating they need 30 to 90 days to retrain staff, reprogram permit application systems, and update forms. They are not openly defiant. They are claiming logistical complexity. But gun rights advocates are watching the clock closely because delay is not compliance. Every single day these states continue to enforce struck-down waiting periods or unconstitutional training mandates. They are actively violating the civil rights of their own citizens and exposing themselves to massive federal lawsuits under Section 1983. The third category is active resistance, and this is where the real legal war is breaking out. New York, New Jersey, Illinois, Maryland, Massachusetts, and Hawaii are openly engineering workarounds, systems designed to comply technically with the ruling while recreating the same burden through different mechanisms. New York is reportedly drafting legislation to replace its struck-down training mandate with a free, voluntary training program, one that just happens to have a 90-day waiting list and operates only in select counties. Voluntary in name. A waiting period by design. New Jersey is exploring replacing its permit to purchase with a mandatory dealer background enhancement system that routes purchases through a state portal with processing times of 3 to 7 business days. Different mechanism, same delay. Illinois is considering whether its existing FOID infrastructure can be repurposed as an enhanced eligibility confirmation system sitting alongside the federal background check. Different label. Same prior restraint. Maryland is looking at adding 10 new objective criteria to its permit process, each individually defensible, collectively designed to create a gauntlet that most applicants struggle to clear. Every single one of these workarounds is going to be litigated. The Second Amendment Foundation, the Firearms Policy Coalition, Gun Owners of America, and state-level organizations are already preparing challenges. And here is why the resistance is doomed to fail. Under strict scrutiny, the government must prove each new restriction is narrowly tailored to a compelling interest, using the least restrictive means possible. These workarounds are not narrowly tailored. They are delays dressed in new clothes, prior restraints wearing different uniforms, and they are going to lose in court faster than any previous challenge because the legal standard is now unambiguous. To understand exactly how extraordinary this moment is, you need the historical context. District of Columbia versus Heller in 2008, which established the individual right to keep a handgun at home, was 5-4. 4 justices dissented. McDonald versus Chicago in 2010 which extended that right to the states, was also 5-4. New York State Rifle and Pistol Association versus Bruen in 2022, which struck down May issue carry and established the historical text framework, was 6-3. Sotomayor, Kagan, and Jackson all dissented in Bruen. Every major Second Amendment victory in the last 2 decades has been a close, contested, bitterly divided decision that left the losing side energized to fight back. Not this one. 9-0 changes everything. It removes any political narrative that this was a partisan result. It eliminates the argument that a future court composition could simply flip the outcome. And it signals, in the clearest possible terms, that the case against these specific restrictions had become in the court's own framing, constitutionally indefensible. When the justices who have spent their careers defending gun regulation look at what states had built and conclude they cannot defend it under any principled reading of the Constitution, you are not watching a close legal question. You are watching the end of an era. This ruling does not just affect what is on the books today, it fundamentally changes what any legislature, town, federal or state, can even attempt going forward. For Congress, the era of sweeping federal gun control mandates is over. Any new federal legislation now has to survive strict scrutiny. Universal background check expansion tied to a federal registry, structurally problematic. A new federal assault weapons ban, dead on arrival. Federal magazine capacity limits, same result. Any federal red flag law without robust, individualized due process guarantees, it will not survive its first court challenge. The era of Congress passing sweeping gun bills and hoping they survive deferential review is finished. For state legislatures, the experimental era of gun control is officially dead. For years, politicians in restrictive states would pass arbitrary restrictions just to see if they would stick, knowing they could drag out legal battles for a decade. Now every law must be historically grounded and narrowly tailored from day one. If a state passes a restriction that lacks a direct historical parallel from the founding era, gun rights attorneys can secure an immediate federal injunction, striking the law before it can even take full effect. For the courts, every pending Second Amendment case in every circuit just got reset. Cases decided under intermediate scrutiny, a standard that no longer applies, will need to be re-evaluated. Challenges to assault weapons bans, magazine limits, age restrictions, and red flag laws are all heading back into active litigation with a dramatically stronger constitutional foundation under their feet. Here's exactly what you need to do right now. 7 steps that protect this victory and ensure you benefit from it personally. Step 1. Know exactly what changed in your state. If you're in California, New York, New Jersey, Illinois, Massachusetts, Maryland, Hawaii, Connecticut, Delaware, or Rhode Island, major restrictions just fell. Spend time today researching what was struck down versus what remains in effect. Do not rely on local mainstream media to tell you your rights. Check updates from trusted gun rights organizations and know specifically what applies to you. Step 2. Exercise your newly recognized rights. If you have been waiting to buy a firearm because of permit requirements or waiting periods, now is the time. The more law-abiding citizens who step up and exercise their rights immediately, the harder it is for hostile state legislatures to engineer backdoor workarounds before anyone notices. Step 3. Apply for your carry permit under the new shall issue standard. If you are in a former may issue jurisdiction, file your application now, before states have time to engineer new objective barriers that slow the process. Getting into the pipeline early matters strategically. Step 4. Document everything. If a dealer, local government, or law enforcement officer attempts to enforce a restriction that was just struck down, write down names, dates, and exact statements. Take photos where appropriate. This documentation is the foundation for a federal civil rights complaint under Section 1983 DOS, and those complaints carry real teeth, including attorney's fees and personal liability for officials who knowingly violate a Supreme Court ruling. Step 5. Support the litigation organizations fighting the workarounds. The Second Amendment Foundation, the Firearms Policy Coalition, Gun Owners of America, and state-level organizations are already mobilizing to challenge resistance legislation. They need members and funding. The workaround fight is going to be won or lost in the next 12 to 24 months, and it will be won by organizations with the resources to litigate aggressively and immediately. Step 6. Track new legislation in your state obsessively. Resistant states will pass bills quickly, using language designed to sound reasonable while recreating the same burdens. Watch your state legislature. Get on alert lists. Oppose any bill that recreates a waiting period under a new name, reestablishes permit prerequisites through a backdoor mechanism, or adds objective criteria so numerous and complex that they function as subjective barriers in practice. Step 7. Vote like your rights depend on it, because they do. This ruling happened because presidents appointed justices who take the Constitution seriously, one appointment at a time over decades. The justices who wrote this opinion serve for life, but the lower court judges who will apply it, and the state officials who will implement or resist it, are determined by elections. Every election, at every level. Gun rights are not protected by a single Supreme Court ruling alone. They are protected by sustained, relentless political engagement from people who understand what is at stake. Here is where we stand. The Supreme Court of the United States just issued a unanimous 9-0 ruling that strikes down 5 categories of gun restrictions in all 50 states and establishes strict scrutiny as the governing standard for every Second Amendment case in America going forward. Permit to purchase systems, extended waiting periods, mandatory training prerequisites, good cause requirements, and discretionary approval processes are all unconstitutional. Immediately, everywhere. The states that lose the most had built the most restrictive systems. Their gun owners are now entitled to purchase firearms without permit cards, clear waiting periods in hours instead of weeks, and pursue carry permits without bureaucratic auditions for their rights. The fact that Sotomayor, Kagan, and Jackson joined this ruling tells you everything about how far gun control had drifted from constitutional defensibility. This was not a close call. It was not even a contested one. But here is what you must understand. The war is not over. The resistance is already organizing tonight. States are consulting with lawyers about replacement systems. Anti-gun officials are looking for ways to preserve their infrastructure under new labels, new names, and new justifications. And gun rights organizations are preparing to fight every single one of those workarounds in court, immediately, aggressively, and under a legal standard that now gives them the strongest possible constitutional foundation. This is the most important Second Amendment victory since Heller, and by some measures it goes further because it establishes the strictest possible constitutional standard and closes the loopholes that allowed previous rulings to be partially worked around in hostile jurisdictions. The question now is not whether you won. You won. The question is whether you protect the win. Share this with every gun owner you know. Most of them have no idea this shift just occurred. They need to know their rights, and they need to know them now. And remember, this is educational information about the Supreme Court's decision and its impact on existing law. Always consult with a licensed firearms attorney in your jurisdiction before making legal decisions based on this ruling. Laws in many states are changing in real time, and the ground beneath this legal landscape is still shifting. All 50 states are on notice. The Supreme Court has spoken unanimously, and the Second Amendment means exactly what it says.